Can you make a refugee claim in Canada if you already claimed asylum in the United States? In many cases, the answer is probably no. If you previously made an asylum claim in the United States, that fact alone may make you ineligible to pursue a refugee claim in Canada. In other words, your case may be stopped before Canada even considers the merits of your fear-based claim. One major reason is that Canada and the United States share certain immigration information. So if your prior United States asylum claim can be confirmed, that may be enough for Canada to find your refugee claim ineligible. There is another major barrier as well. If the United States has already granted you asylum or another form of protection, Canada may decide that you have already been recognized as a refugee or as a protected person in another country and can be returned there. In that situation, the fact that you still do not have a green card does not necessarily help you. A pending or delayed green card does not automatically preserve eligibility for a refugee claim in Canada. There is also an important warning sign. If you renewed or obtained a passport from your country of origin after claiming protection, that can seriously hurt your case. Why? Because it may be seen as re-availment, meaning that you turn back to the protection of the same country you once said you feared. It does not automatically destroy the case every time, but it is a significant negative evidence and usually needs a strong explanation. If you are trying to enter Canada from the US at an official land border, the safe third country rules may also apply. In some situations, having a qualifying family member in Canada, such as a child who is a Canadian citizen, may help you through a family member exception. But this is very important. Having a Canadian citizen child does not automatically erase every other legal barrier. So what if a refugee claim is not available? There may still be another possible pathway, what is called a humanitarian and compassionate application for permanent residency, often called an HNC application. But this is not a substitute refugee claim. You cannot simply repackage the same fear narrative under a different label. An HNC case must focus on hardship, family ties in Canada, establishment, and especially the best interests of any child directly affected. If you have a child who's a Canadian citizen, that may be an important factor in an HNC application, especially if the child is still a minor and your absence would seriously affect that child. But success depends on the strength of the evidence, not just on the family relationship itself. The practical takeaway in this is that if you already claimed asylum in the United States or if you already received protection there, there is a strong possibility that a refugee claim in Canada will face a legal bar. In that situation, an HNC application may be a more realistic option, but only if it is prepared carefully and supported by strong evidence. If this sounds like your situation, get legal advice before taking any step, because one small detail, such as the exact nature of your U.S. status or why you renewed your home country passport, can completely change the outcome. My name is Samin Mortazavi, and I'm a lawyer at Opax Law in North Vancouver, Canada.